of the case law that you have read. All right. If you have any questions in between, please feel free to ask. You can stop me. You can write the question in the chat box, and I would be happy to address those questions. And as I said, that this is a basic session on how to write a case brief. I would also expect you to contribute your opinion or your understanding of what elements should be there in a case brief or what is a case brief and so on. So let's start with a basic question as to what is a case brief. What do you understand by a case brief? So when you are given a topic or a case, and when you have to write a brief, what all do you keep in your mind while writing a case brief? You can use your mic. You can write in the chat box as well. So what are those elements that you? All right, Arnav, that's okay. What are the elements that you take into consideration, or just let me know what do you understand by a case brief? I'm waiting for a response. Brief facts, legal issues, and then the judgment.
I think some of you can try switching on their audios at least. Like it won't require the network, proper network. Audio can work with low network also.
Prominent facts without cost them and the judgment held along with the ration arbiter dicta. All right. Brief facts, legal issues, and then the judgment. Okay. All right. So these are the elements that you take into consideration. Okay, that's correct precisely. It is a structured outline of the various nuances, facts, arguments, or are covered in the judgment. Okay. So what basically you're trying to do through writing a case brief is you're trying to encapsulate or analyze the whole judgment in brief, right? So it is not just the facts or the ratio or the arguments or the judgment separately, but you're trying to understand it as a whole. You're trying to make a connection between all these aspects of a given judgment. So the first and the most important thing before you write a case brief is to read the judgment. So what I have observed in a lot of case briefs that I receive for review is that you refer to other case briefs. ठीक है, जैसे किसी ने लाइव लॉ से देख लिया, किसी ने किसी और वेबसाइट से देख लिया कि कोई और केस ब्रीफ है, and then you read those case briefs and then you rewrite it on your own in your own words. So that's not how you should write a case brief, because it is your case brief. You can't write your brief by referring to someone else's case brief. So the first important thing is that you should read the whole judgment. And tell me honestly, how many of you read the whole judgment? I know it is a tedious task to read the whole judgment, but you can't really write an effective case brief without reading the whole judgment. अगर आप सिर्फ किसी और के case brief या किसी और website से लेंगे, then it will be a, it is something that can be considered as that you have referred to or you have copied from someone else's case brief. So you may not be able to reproduce your thoughts. So case brief is not just about writing facts or arguments or reasoning. It is also about reproducing, or it is also about bringing your own thoughts or presenting it to the reader that this is what you think about the judgment. All right. So hence it is very essential for you to read the whole judgment. And while reading the whole judgment, what you should do is keep highlighting. आप annotations कर सकते हैं, आप highlight कर सकते हैं. So you already have a structure in your mind, as some of you have mentioned कि facts होंगे, arguments होंगे, issues होंगे. So you should keep highlighting that, okay, this is something that will help me, or this is something that will be covered under issues or facts. And why is it necessary? This is necessary because courts does not always clearly lay down कि हाँ भाई ये facts हैं या ये issues हैं. So it is the reader who has to find out that, okay, this is the issue that courts have addressed, or this is the argument laid by the parties. Sometimes it becomes confusing when you read a judgment. Everything looks that, okay, this is a this is repetitive. We have earlier read it in the first paragraph, and now again it is being mentioned again. So that's the reason it is important for you to keep highlighting things, starting from facts, that these are the relevant facts, these are the issues, these are the arguments, and the reasoned decision. So please, while reading the judgment, keep highlighting so that you don't forget when you start writing the case brief. All right. So first thing is that read the whole judgment. So it is only Kamal who has mentioned that he reads the whole judgment, and no other participant has mentioned that they read the entire judgment before writing it. Okay. Anyway, so then comes the next question as to what will be the first or what is the first thing that you should mention in your case brief. It may be in a point, it may be in a paragraph, but what is that first thing or the first paragraph that your brief should comprise of? Yes, anyone? I have 3 samples also that I'll show you, but before that, let's understand the elements and then we will look at the samples. So tell me, what should be the first paragraph when you write a case brief? Shashwat. Facts. Vansh, facts, Shashwat, bench. Case name and the date of the order judgment and a line of what was held. Okay. All right. So there are different ways of starting a case brief, let's say. I look at various case briefs that are submitted by you, and you all have your own style of writing, right? But essentially what the first paragraph of your case should be, that you should mention the name of the parties, or you can say case name, or the court that has given the judgment, or like Tejaswini said, and a line of what was being held. So as a reader, when I read these things, I have a clarity in mind that, okay, this judgment comes from this court, these are the parties, and this is the judgment, or this is what was held by the court. So whether I'm interested in reading it further or not will depend upon how your first paragraph is. If your first paragraph is confusing, all right, or if it does not highlight the relevant aspect of a judgment, then as a reader, I might not be interested in reading your case brief. So it is very important to start with the party's name, or you can say the case name, from which court it comes, and in brief, what was the rule of law, you can say, or what was the rationale or the judgment that was given by the court. All right. Again, there's no hard and fast rule that you have to start in this manner only, but in whatever style of expression or whatever way you write, the first paragraph more or less should cover the case title, date, and the court name. All right. So it does not matter कि आपको ऐसे ही लिखना है, but आपको first paragraph में ये information आनी चाहिए. All right. Then it can be another paragraph or a part of this paragraph only, clearly lay down as to who is the plaintiff and who is the defendant. Okay. Sometimes it happens that I read your case briefs and I'm not able to understand कि भाई plaintiff कौन है या defendant कौन है और appellant कौन है. All right. Usually confusion होता है जब कोई appeal जा रही होती है तो आप straight away if you're writing appellant. So I would want to know कि appellant कौन है, plaintiff था या defendant appellant है. So in those cases you should write appellant and in bracket में plaintiff or defendant. All right. So there's a particular style of writing these things. So you should refer to those legal terms, or you can say you should refer to those legal language. All right. So you should clearly lay down as to who's the plaintiff or who's the defendant. आप ऐसे भी लिख सकते हो शॉर्ट में भी, अगर आप कुछ बताना चाहते हो कि प्लेंटिफ के ब्रैकेट में आपने पार्टी का नाम लिख दिया और डिफेंडेंट के ब्रैकेट में आपने पार्टी का नाम लिख दिया. So when you have written it for the first time that plaintiff is this or defendant is this or appellant is this or respondent is this, then later on you need not to write it again and again. आप दोबारा से फिर सिर्फ plaintiff या defendant लिख सकते हैं. But when you're writing for the first time, make sure the name of the party is identified with whether they are plaintiff or whether they are defendant. All right. ये बहुत ही common mistake है जो बहुत सारे बच्चे करते हैं when they are writing a case brief, that you don't identify the parties as whether they are plaintiff or they are defendant. All right. So please make sure that you have done this in your coming or in your whatever case briefs you write in future. Then comes the facts. All right. So first paragraph में आपका हो गया case name, parties, date of judgment, which is the court that has given the judgment, and in brief, align what was held in the court or what was the rule of law that was applied. So this should be your first paragraph. And how do you write it? It's up to you. So you can start with a story. You can start with the facts in brief, but essentially this should be covered in the first paragraph. Then comes facts, right? Now, how do you identify that this fact is relevant or this fact is not relevant? Because you can't really write the entire facts in your case brief, right? Judgment में जितने भी facts हैं हम वो सारे नहीं डाल सकते. So how do you identify that this fact is going to help me and this fact may not be relevant for the purpose of case brief? Yes, anyone? So I've made a document also on case brief. I'll send it to you. But before that, let's understand your. If it is in regard to anything which affects the judgment, it's relevant. Absolutely correct, Vansh. Please specify only IP related facts if it involves other aspects as well. Okay. Tejaswini, your answer is specific to IP, which is also correct, but I think Vansh has, answered it correctly. That anything that helps you to reach to an outcome, right? So you have to keep your focus on those kind of facts that determine some outcome. All right. So let's say if the dispute relates to trademark or copyright or patent. Let's say there's an entertainment company that has rights over numerous music videos or music audios. All right. That company may also be involved in some other cases too, or they have some other businesses. And if the dispute is only with related to copyright, then you need not to talk about trademark. Even if the judgment has some reference or it does talk about facts related to trademark. So you have to only refer to those facts. So keep your focus only on those facts that are relevant to achieve a particular outcome. And how do you know what is the outcome? It will depend upon what is the issue or what has been held by the court. Okay. And hence that is the reason it becomes important to read the entire judgment. अब आपने सिर्फ फैक्ट्स लिखे, कुछ कभी कभी हम ये भी करते हैं कि पढ़ते जाएंगे लिखते जाएंगे, right? So you read the facts and then you briefed it. Don't do that because you never know which fact is relevant, which fact is not relevant. You will only know that once you've read the whole judgment or what has been held by the court. Okay, so that's how you can save your word count as well. So you need not to write facts that are irrelevant. Write only those facts that are relevant. And whether they are relevant or not will depend upon what is the judgment. All right. And there can be another aspect of facts as well, which is procedural fact. So fact एक हो सकता है कि अभी तक क्या हुआ? What is the story? All right. The other aspect of fact is procedural facts as well. Procedural fact का मतलब हो गया, let's say पहले matter lower court में था, all right, या trial में था, depends upon what kind of dispute it is. And then आप appeal में गए, फिर appeal से एक और appeal में गए. So you have to write कि पहले brief में कि पहले court ने क्या decision दिया, and then that decision was upheld by the appellate court or it was reversed by the appellate court, and then again you went in appeal second time. So it depends whatever the procedure is. So you can mention that procedure. Again, now the question arises whether procedural history is important to write as facts or not. So it will depend if the question of law that you're addressing in the case brief relates to procedure. Okay? In that case, it becomes important to refer to the procedural history. But if it does not actually relate to any question of law which relates to procedure, then you need not to focus too much on the procedural history. Are you getting my point? Are you getting my point as to whether you should mention procedural history in the facts or not? Yes. So mention it in brief. कि
Yes,
हाँ
ma'am.
इस कोर्ट से अब यहाँ पर आया था. अब this question is being addressed by the court. But in case जो dispute है वो ही procedure को लेके ही है, तो फिर आपको थोड़ा ज्यादा focus करना पड़ेगा procedural history में. ठीक. All right. So it depends. So there are few cases जहाँ पे court procedure से related होता है या evidence से related होता है. So it is not actually addressing some fact, right? कोई dispute को address नहीं कर रहा है, but एक procedure को लेके कोई question है. In those cases आपको procedure के बारे में ही बात करना. Otherwise, you need not to focus too much on the procedural history. All right. So are you clear with this first paragraph about the parties, court, date, and then you come to facts that are relevant, and it should also include procedural history, if any, again, whether it is relevant or not. Then comes the third part, which is what will be the third part or the third element? Yes, anyone? What should be the third element? It's very easy to answer, please. Arnav, can you answer this question? Arnav, Ananya, Nityanand, arguments. Before Tejaswini, you are missing something. Before contentions or before arguments, there will be something else too. Issues, exactly. ठीक है? Facts के बाद issues आएंगे. Right? So issues, what are issues? Issues are basically the legal questions that are being addressed by the court. Kamal is also writing something. Kamal, should I wait for you to finish? I mean, आप कुछ लिख रहे. Okay. So then here comes issues. Now, how do you find out the issues in a given case? ऐसे बहुत clearly नहीं लिखा होता है judgment में या किसी case में that these were the issues addressed by the court. So how do you actually find out the issues? Conflicting interests are issues. Okay. All right. Okay, let's see. Let me put up a question and then you answer my question. All right. So let's say Arnav has a business and his trademark comprises of his name Arnav, and there's some color combination and so on. So there's a logo that Arnav uses. Okay. Ananya also has a business, and Ananya's logo is also something similar to Arnav. All right. These are the facts. Then Arnav filed a suit against Ananya, contending that she has copied my logo and hence this is trademark dispute. All right. Now you tell me, इसमें क्या issue बनेगा? Okay, that's Tejaswini, right? Legal issues, who is entitled to the logo? All right, ठीक है. Let's say अर्नव के पास registration है, अनन्या के पास registration नहीं है. So then how do you draft an issue? आपको issues वैसे case में मिल जाएंगे. अगर आप पढ़ोगे, you'll be able to frame the issues. But let's, whatever facts I've stated, tell me how will you draft an issue? Legal issues, who's entitled to the logo. Okay, Kamal has mentioned this. Anyone else? Can someone use a registered logo? All right. Okay. Tejaswini, whether there was a distinctive similarity between the two marks, correct? If yes, then in what circumstance? All right. Okay. Okay. I mean, more or less correct. Tejaswini, whether the other mark has obtained a quite distinctive over the use of the two marks. All right. All right. So issues will be not an issue of fact, right? It should not be framed like ये आप कोई factual question पूछ रहे हैं. It has to be a legal question which relates to law. Okay. So अगर question ये आता है whether Ananya can use Arnav's logo or not, then it is a factual question. It does not sound like a legal question, right? So the question should be like one maybe Tejaswini framed, whether there was a distinctive similarity between the two marks, because this will actually decide whether act of Ananya amounts to trademark infringement or not. Right? So you have to draft a legal question, not a factual question. So you have to relate it to the law. Other issue that can be drafted in this dispute is whether Ananya's use of the logo is likely to cause any confusion in the market or not. Right? So these are legal questions here. So whether Ananya can use Arnav's trademark or whether Ananya can use a mark which is similar to Arnav's trademark or not will depend upon whether the law permits it or not. So you have to draft the question accordingly. Ki law kya permit karta hai? So maybe like what Tejaswini has mentioned, whether the other mark has acquired distinctiveness over the use of two marks, or whether there was a distinctive similarity between the two marks. So these are the questions, these are the issues more or less that you should draft in these circumstances. All right. One that Kamal has mentioned as to who is entitled to the logo. All right. Ye question, I mean, it is also correct to some extent, but usually in disputes में factually mentioned होगा. Right? ये factually आराम से बताया जा सकता है कि whether Arnav has registered the mark or not, whether Ananya has registered the mark or not. So you should rephrase it in a different manner. Right? So how do you rephrase it? You will write as to who is the prior user of the mark. Are you getting my point, Kamal? Prior user is the legal term. So rather than saying who is entitled to the logo, you should write who is the prior user of the mark. So maybe because that will determine as to who has a better title to the mark. All right, Kamal, you will learn this. It only depends upon whether you know the law or not, whether you know the correct terminology, whether you know the legal language or not. So this is again one of my point in my discussion today, that जब भी आप केस ब्रीफ लिख रहे हैं, please use the legal language. उसका कोई synonym नहीं हो सकता, right? अगर मैं prior user बोल रही हूँ, तो prior user का कोई और synonym use करने की जरूरत नहीं है, because even the law talks about prior user, right? So use the legal terminology wherever required. And whenever you're referring to जैसे appellate हो गया, appeal में matter जा रहा है, so whether code has the appellate court has upheld the previous decision or not. So you have to use those words: upheld, reversed. All right. So please make sure that you are careful about using these terms while writing your case briefs. Okay. So issues are not a question of fact. Please remember this. क्योंकि जब आप draft कर रहे होते हैं ना, मैंने कई case briefs में देखा है, ये बहुत ही factual question लिख देते हो आप. Or of course, I understand it depends upon your knowledge of law. अगर आपने नहीं पढ़ा होगा trademark और आप first year में हैं या आप second year में हैं, तो आप नहीं draft कर पाओगे उस हिसाब से issues. But please keep this thing in mind. Issue is not a factual question. It has to be a question of law. Is it clear to everyone? Any question in this? तो जब आप जजमेंट पढ़ोगे आप आराम से ड्राफ्ट कर सकते हो वहां पे देख के कि कोर्ट ने किस तरीके के इश्यूज पे बात कर रहा है, मिल जाएगा आपको. It's just that you should understand how to extract an issue from a judgment if it is not written in the judgment. All right. Okay. Then comes your arguments. So arguments from both the parties. अब फिर again you will be in a dilemma कि हमारे पास word limit तो बहुत कम है, but arguments कितने arguments लिखोगे आप? So again, refer to relevant arguments. All right. कि plaintiff के ये arguments थे और defendant के ये arguments थे. Brief में. Contentions comprise of both facts and legal aspects. Yes, Kamal. But again, relevant facts, जो legal aspects से related हो. Kamal, can you give me an example? It would be better to understand it through an example. For example, let's say हम prior user की जैसे बात कर रहे हैं. Kamal, do you understand prior user concept in trademark? हाँ, ठीक है. तो जैसे हम prior user की का contention दे रहे हैं that I am the prior user. Alright. तो अगर आप उसमें date refer कर रहे हो that I started my business from so and so date. तो ये fact है, but ये यहाँ पे आप mention कर सकते हो because you are supporting your argument of prior user. Alright. तो वहां पे ये मेंशन कर सकते हो आप. इनफैक्ट आपको करना ही पड़ेगा अगर आप डेट की बात कर रहे हो. Prior user will have exceptions. Exceptions in the sense that yes, if there is no likelihood of confusion in the market, then that will be an exception. Okay, let's not go into the exception part. We are just talking about कि अगर आप if you are mentioning in your contention that you are a prior user, then it can be followed by a fact which states कि आपने इस date से या इस year में अपना business शुरू किया था. So that can be mentioned. Okay. Right. Then comes your next, after arguments, your next paragraph should comprise of the rule of law which is applied and what was held by the court and the reasoning. Right? ये बहुत important part है. Because this is where all your analysis of the judgment will come into picture. Or as a reader, I would be interested to know what did the court say. Right? Facts तो सही हो गए, arguments भी हो गए, all these things are important. But the most important part would be what did the court say? And how did the court reach to a conclusion? Okay. So in a lot of case briefs, I find कि आप facts लिख देते हो, आप arguments लिख देते हो, फिर आप judgment सिर्फ 3 लाइन में लिख के खत्म कर देते हो. Because of the maybe आपका word limit कम हो गया या फिर आपने ठीक से पढ़ा नहीं होगा. Could be because of so many reasons, right? So holding and rationale, these are very important part of a case brief. So you will start with what is the rule of law? Rule of law as in what law has been applied by the court? What interpretation did the court put forward? And what was the rationale behind the judgment? ठीक है, एक तो चीज ये होगी कि कोर्ट ने बोला प्लेंटिफ के फेवर में मैटर जाता है या डिफेंडेंट के फेवर में जाता है, बट क्यों जाता है इज रेलिवेंट. Alright. And you have to look at that all these things are related. You started with facts, relevant facts, arguments, and then what have the court held? And one more thing, what also I've mentioned is कि कभी-कभी आप लोग multiple issues लिख देते हो. जैसे आपने 3 issues लिख दिए, but आपने argument सिर्फ एक ही issue कर दिया, या judgment सिर्फ एक ही issue कर दिया, right? Has it happened with you? I mean, I have come across a lot of case briefs like this, that you have mentioned 2-3 issues, but you have addressed only one issue. So in those cases, what you should do, that you may mention 3 issues, ठीक है, but उसके बाद आप लिखिए that the most important issue was this, which has been dealt with by the court, or which is, and only that issue you will be dealing with in your case brief, because that is the most relevant issue. Right? Are you getting my point? Kamal, I'll come back to your question. So please be sure कि आप अगर एक 3 issue लिख रहे हैं, तो at least you should be clear as to which issue are you addressing in the case brief. All right? Because it happens that not every issue is important, even if it is mentioned in the judgment. Right? Okay. Now coming to Kamal's question, many a times it becomes difficult to distinguish the ratio from obiter dicta. How can we understand it? Okay, Kamal, so that I understand it's a difficult, but do you understand the difference between ratio and obiter dicta? I'm sure you do understand the difference between the two. See, it again, when you are reading the judgment, you will come across, different paragraphs. Again, in the judgment, it is not mentioned, ऐसे नहीं mention होता कि ये obiter dicta है या ये ratio है. You have to find out. वो आप जब issues पढ़ रहे हैं, arguments पढ़ रहे हैं, आपको उसी से समझ आएगा. कभी कभी कोर्ट थोड़ा सा क्लियरली मेंशन करती है that this is the, जैसे observed लिखा हुआ है कहीं पर, तो that is only an observation given by the court, right? कहीं held लिखा हुआ है, तो उसको आप रेशियो से रिलेट कर सकते हो. तो यू हैव टू अंडरस्टैंड दीज वर्ड्स कि कहाँ पर कोर्ट कैसे लैंग्वेज यूज कर रहा है. ओनली फ्रॉम दैट यू कैन अंडरस्टैंड दैट दिस इज द रेशियो और दिस इज द ओबिटर डिक्टा. ओके, क्योंकि ओबिटर डिक्टा बहुत सारा होता है जजमेंट में. यूजुअली व्हेन कोर्ट्स आर रेफरिंग टू अदर केसेस, राइट, उसमें बहुत सारा ओबिटर डिक्टा होता है. Yes, Kamal. Many a times they mention observe and give it as a reasoning of the held. So in that case what you do कि जहाँ पे usually end में held होता है, right? Last के जो paragraphs होते हैं वही court का judgment होता है या rationale होता है. So you can refer to that as rationale. It is actually, there's no heading that this is the obiter dicta, this is the ratio. You have to extract that, or you have to draw, or you have to apply your understanding as to this is related to ratio, this is related to obiter dicta. Okay, maybe what I'll do, I'll highlight some aspects of a judgment which I understand that this is the obiter dicta or this is the ratio, and I'll write my reason there, that how did I draw that conclusion that this is the ratio and this is the obiter dicta. Is that okay, Kamal? I can do that. All right. Okay. And then another important part is dissent. ठीक है, आपको हर जजमेंट में डाइसेंट नहीं मिलेगा, आईपी के केसेस में स्पेशली. बट अगर मैटर कोई बहुत पब्लिक इंटरेस्ट से रिलेटेड है, मे बी यू विल कम अक्रॉस सम सॉर्ट ऑफ डाइसेंट. सो इफ देयर इज अ डाइसेंट, then it will be very interesting for the reader to read what is the dissent. Okay, तो आप dissent भी mention कर सकते हैं. You will find a lot of dissents in other areas like constitutional matter में आपको dissent मिल जाएंगे बहुत सारे. IP के disputes में आपको कम मिलेंगे. Yes, हंसराज खन्ना लैंडमार्क डाइसेंट. तो अगर डाइसेंट है तो आप लिखिए, बहुत इंटरेस्टिंग होता है एज अ रीडर डाइसेंट पढ़ना. ऑलराइट, एंड देन व्हाट विल बी द लास्ट पार्ट? इंस्टेड ऑफ कंक्लूजन, प्लीज डोंट से कंक्लूजन. ठीक है, बिकॉज आपको इसमें आप कुछ कंक्लूड नहीं कर रहे हो. केस ब्रीफ में आप कमेंट लिख सकते हो, योर एनालिसिस, राइट, आप एनालिसिस लिख सकते हो. So I would suggest that rather than using the, heading as conclusion, you should write your comment or your analysis, right? And comment and analysis is where you can give your own personal comment. This is one opportunity where you can put forward your understanding or your analysis or your arguments. If you do not agree with the judgment, you can write that too. So these are, yes, author's view. These are your views. This is your way of comprehending the judgment or the case law that you've heard. Okay, so instead of writing conclusion, please use some of your understanding of the law, write comment or write analysis. All right. Now there are certain things that I've mentioned while referring to your case briefs. One is that I come across a lot of case briefs where the author has either written two long sentences or two short sentences. ठीक है, अगर बहुत लंबे sentences होंगे, then as a reader I might lose my concentration. मैं भूल जाऊंगी कि मैंने क्या पढ़ा था, बहुत लंबा sentence है. And if the sentences are too short, then it doesn't look good, right? Because you have to connect two sentences if they are connected to each other. You can't just write one. For example, if I write, my name is Charu, I am so and so, right? Or if I'm referring to someone else, I'm writing, Kamal is a student, Kamal studies in so and so university. So rather than writing these two fragmented sentences, I should combine them by using conjunctions, right? So you should please, be careful when you're writing. Don't write too long sentences. Don't write too short sentences. And whenever you start sentences, एक चीज मैंने और देखी है, you have to use the correct word, right? For example, you should use words like moreover, in addition, however, when you're introducing new paragraphs, right? Tell me, when will you use moreover? These are very important things for writing your case briefs or any piece of writing. When do you use moreover? ये हमें पता होता है, but when we are writing, we don't use these terms when we are starting paragraphs or connecting two sentences and so on. Additional info, okay. So you can use the term moreover or in addition to. However, when do you use the word however? Punch, correct, to provide a comprehensive view of all that being said. When do you use however? Despite that, correct. So please make sure that you're using these words. Again, legal language it makes a lot of sense. When you're starting a paragraph or when you're trying to make a connection between two paragraphs or two sentences, use these words. Okay. However, to introduce a contradiction. Okay. So when you're writing a conclusion, आप इस तरीके के words use कर सकते हो. So having said that, yeah, having stated whatever has been held by the court, this is your view. So you can use those kind of words. All right. One more thing that don't use contractions. For example, ये बहुत, it looks very informal. Isn't, wasn't, wouldn't. ठीक है, पूरा लिखो. Is not, was not, would not. All right. Don't use these short forms when you're writing something. It looks very informal. And one more thing. When you're writing your personal opinion, give support it by some law, right? You should not just write, I believe that this should have been held by the court. No one is interested in knowing that what you believe. They would only believe you once you have given or once you have, substantiated your statement with some law or with some case law, let's say. So let's say if you do not agree with the High Court decision, and then you're writing in your personal commentary that Supreme Court in a previous matter on similar facts have said this, and High Court erred in referring to Supreme Court's interpretation, right? So when you're writing your personal opinion, just don't write your opinion without substantiating it with a piece of evidence or with some case law or with some your understanding of interpretation of law, right? Understood? This is very important because when I write conclusion, I see a lot of, random statements without any reference to any case law or without any reference to any provision of law. So it has to sound like actually a sound opinion and not just any opinion. Okay. Let me now show you a couple of samples. Before showing this sample, that whatever I've discussed in today's session, there's no hard and fast rule कि आपको इसी sequence में चलना है कि पहले हमेशा पार्टी का नाम ही आएगा, फिर issues आएंगे, फिर arguments आएंगे, फिर decision आएगा, फिर personal opinion आएगा. आप you can write it like a story too, right? ऐसा कोई sequence जरूरी नहीं कि आप ऐसे ही follow करो. If you're a very good writer, then you will be able to narrate it like a story. All right. But if you're not a good writer, if you are if you are naive in writing, you've just started writing, then follow this sequence because it will be easy for you and it will make sense for the reader too. But if you know writing, if you're very good at writing, then you can resort to different styles of writing. All right. Right. Let me now show you a couple of samples. Can you see my Manya, can you give me the rights to share my screen?
You have the rights.
I can't.
Beside share button, you can see beside the leave button. You will find the share option.
No, there is a share option. I'm clicking on the share option, but
Oh.
share content, control shift E. अच्छा ठीक है got it. Okay. Can you see my screen?
Yes, ma'am.
I won't be able to see your text in the chat box, but this is one case brief, protecting copyright in the digital age, a case analysis. You can frame your title like this. ठीक है, कभी कभी आप लोग सिर्फ केस का नाम लिख के सबमिट कर देते हो. Don't do that. All right. Draft something, write something. It should look like a title. So when a reader looks at your case brief, तो मैं अगर title भी देखूंगी तो मुझे समझ आ जाएगा and I will be interested to read your case brief. But अगर मैं सिर्फ नाम देखूंगी, then I might not, be interested in reading your case brief. I might read something else. So please draft or put some title in your case brief. And then this author has written the case citation and then starts with the introduction. Okay. And this is one of the good ways of writing a case brief. The case of Universal, so the author has mentioned the name of the party, hereinafter referred to as plaintiff. Please do this, right? So that the reader is clear. तो आगे जब आप plaintiff लिखोगे, आपको दोबारा Universal City Studios लिखने की जरूरत नहीं है. You can straight away write plaintiffs. Okay. So the author has written introduction, procedural history, issues presented, rule of law, contentions, analysis, holding in decision. So this is one of the case briefs that I came across and I found it good. And if you want to look at the sample, I can ask Manya. She can share the samples with you. Another is okay. Is my screen visible?
Yes, ma'am.
Yes.
Okay. This is another case brief or IP hotshot. I think this is written by Tejaswini, if I'm not wrong. Yeah. This is also a good case brief. Okay, title is Delhi High Court holds Google liable for trademark infringement ads program. And then in the first paragraph itself, she mentions the name of the case. And in short, what has been held by the court. Okay, so you can refer to this case brief as well. And then there is another that this case brief. I don't know who has written this case brief, but this case brief would definitely need a lot of editing. All right. It has a lot of fragmented sentences and there's no coherence between the sentences or between the paragraphs. And it could be because of the reason that the author does not have a good understanding of trademark law. So if you look at the issues, even issues are not drafted properly, whether the infringement of the trademark is there or not. This can't be an issue, right? So it has to be drafted like a legal question. Then whether the plaintiff should be entitled to any relief or not, and then, random issue 1, issue 2. This is not how you write a case brief. Court analysis, relief granted. Anyway, so there are, a number of case briefs with different style of writing. Every person has a different style of writing, but more or less one should adhere to, a particular standard that is expected from a case brief, or particular information that a reader expects from a case brief. No matter how you write, all this information should be there in a case brief. Okay. All right. If you have any question now, please ask. I can share you with the document that I've prepared on do's and don'ts. And if you wish to refer to that document, please let me know. All right. Any question from anyone? Okay. Okay. There's a very interesting exercise जो आप कर सकते हो खुद भी. If you want to do it, I can just tell you how to do it. So what you do is that you write few statements or related statements. ठीक है? आपको कुछ statements लिखने हैं और related, and it can be anything, random statements. कुछ भी हो सकता है. आपको कोई story बनानी है, कुछ fact बनाने हैं, आप कैसे भी statement लिख सकते हैं. For example, I write that my dog is beautiful and is smart. ठीक है? एक ये statement हो गया. उसके बाद मैं एक और statement लिखती हूँ related, फिर एक और statement. Now what I have to do is I have to justify my statements. ठीक है? This is a very interesting exercise. आप अकेले भी कर सकते हो, आपस में भी कर सकते हो. It can be like a game. So you write 4 to 5 statements, related statements, and then what you do is you write arguments. Again, ये सारा factual है, इसमें कुछ law नहीं है. You write arguments to support your statement. ठीक है? आपने 5 statement लिखे, फिर आप 5 arguments लिखिए हर statement को justify करने के लिए. And ये सब factual है. ठीक है? आपने एक बार आर्ग्यूमेंट्स लिखे, फिर आपको उन्हीं आर्ग्यूमेंट्स के काउंटर आर्ग्यूमेंट्स लिखने हैं. एक बार आप ही ने जस्टिफाई किया, फिर आप ही को उसको काउंटर करना है. एंड दिस विल हेल्प यू टू डेवलप अ वेरी गुड क्रिटिकल थिंकिंग acumen. Okay, this is a very interesting exercise. I suggest you to do this because this will also help you in writing and developing good argumentative skills. ठीक है? As a lawyer अगर आप ये एक्सरसाइज करोगे आपको बहुत मजा आएगा. Okay. Any other question? How to ensure that a brief is short, crisp, as well as complete at the same time? We include everything in the word limit may be breached, which will make the newsletter longer. Vansh, Manya, have you told them the word limit also for the case brief?
Ma'am, actually, we have two things going on. One is IP Hotshot, which we publish, like you saw of Tejaswini. Other thing is newsletter. So, what we are doing is we are compiling all the recent updates related to IPR in the newsletter, like we used to do that, like Tanya or Sushmita did last year. So we are doing the same thing. So what happened in the August edition? The newsletter went to 24 pages. So it was too long for anybody to read those briefs. So for newsletter,
हमारे न्यूज़लेटर में यही होगा ना, जो हमारे ऑलरेडी पब्लिश्ड आर्टिकल्स हैं उनका लिंक होगा with a paragraph of explanation, right?
yeah, maybe our blogs also, but also some recent updates. Normally, like Delhi High Court held in that case, like 2-3 lines, 3-4 lines, which we used to write. So if you can tell them also like how to cover in that newsletter, that would be better. Like what to cover in the newsletter.
Recent updates में पता क्या होता है, अगर आपको सिर्फ 3-4 लाइन लिखनी है न्यूज़लेटर में, माने सिर्फ 3-4 लाइन ही चाहिए आपको.
हाँ जी, तो इम्पोर्टेंट थोड़ा सा बस ये बताया कि अच्छा इस केस का ही हेल्प हुआ,
तो फिर सीधे अपहेल्ड लिखो. हाँ, और कुछ सुनने की जरूरत नहीं, because you don't have that word limit. You don't have that luxury to include everything. So if it is a newsletter, जहाँ पे आपको सिर्फ बताना है 3-4 लाइन में कि what is it about, just write what was held by the court. But don't write this was held by the court or the court held this in this case. ठीक है? Don't write it like this. Write it like कि whatever. आपने पहले लिंक शेयर करोगे. ठीक है? अगर आप एक लाइन में फैक्ट बताना चाह रहे हो, अगर आपको टाइटल से फैक्ट क्लियर हो जा रहे हैं तो दोबारा लिखने की जरूरत नहीं है. पर अगर टाइटल से फैक्ट क्लियर नहीं है तो आप एक लाइन में फैक्ट लिख सकते हो, and then you can write what was held by the court. Okay. Just don't write the court held this. Not like that. माने I need to look at the newsletter. आप मुझे दिखा दो, मैं पर देखूंगी कि कैसे लिखा हुआ है. Only then I can suggest कि इसको कैसे लिख सकते थे हम. Because I don't
ठीक है
know how
मैम,
have you
आपको
written it.
अगस्त वाला भेज देते हैं, पर आप अपने कमेंट्स बता देना एंड देन
हाँ,
आई विल शेयर विद देम।
ठीक है, ठीक है, ठीक है.
ठीक है,
Done, done, done.
ओके। एंड डू यू हैव एनी अदर क्वेश्चंस फॉर मैम?
And केस ब्रीफ के लिए IB हॉटशॉट्स के लिए क्या वर्ड लिमिट है मान्या?
मैम कोई वर्ड लिमिट नहीं दिया
कोई
आईपी
वर्ड
हॉट
लिमिट
शॉट्स
नहीं
के
है ना.
लिए।
But again, not more than 1,000 words.
Yeah, 1000 is like general art blog limit only, blog word limit.
ठीक है, ठीक है. Once I think you can write a case brief in 800 900 words. As I said, आपको हर चीज नहीं लिखनी है. ओके, आपको समरी लिखनी है बस, जो फैक्ट रेलिवेंट है, जो इशू से रेलिवेंट है. अगेन व्हेन यू आर राइटिंग अ केस ब्रीफ, मल्टीपल इश्यूज एड्रेस करते हैं, राइट? लेट्स से आईपी इन्फ्रिंजमेंट का कोई डिस्प्यूट है, तो आपको सारे इश्यूज एड्रेस करने की जरूरत नहीं है. आप बस जो रेलिवेंट इशू है वो एड्रेस करने. If you're addressing the relevant issue, you're mentioning the relevant information, it can very well be covered in 800 words. It is not a paper, right? It is just a case brief. So 800 words is more than enough. Any other question? Okay, all right. In case you have any other question, please you can text me or you can ask Manya. I will be happy to address. Okay.
Thank you.
All right.
Thank
Thank
you,
you.
ma'am. Thank you, ma'am, so much.
Thank you,
It was
everyone.
good to
Thank you.
see you at
Thank
this
you.
talk.